Today's courtroom session is packed with tense moments as defendants face serious charges ranging from DWI and probation violations to assault and bond hearings. Watch as the judge delivers tough decisions, issues final warnings, and makes it clear that excuses won't outweigh accountability. From revoked bonds to emotional courtroom exchanges, every ruling carries life-changing consequences. Stay with us until the end to see how these cases unfold, and don't forget to like, subscribe, and turn on notifications for more real courtroom footage.
Ms. Ortiz, you're charged with driving while intoxicated. It looks like you were placed on probation for this DWI. It is alleged now that you have violated that probation. Is this still an open case in Barrett County? Okay, so we're not going to go forward on that one. I guess let's do the VIP. You know, one of the things is that you have to plead true to these allegations, right?
Yes, Your Honor.
And the problem is that if you plead true to one of the open cases, that could essentially hurt you, and it's not what we're trying to do here. So what we'll go forward is it true that you failed to participate and complete the DWI victim impact panel as alleged? Okay, I'm going to find that it's true. I'm going to revoke your probation. I'm going to sentence you to 30 days in jail. I'll give you credit for the 5 days that you've done. I am going to suspend your license for a year, man. Do not drive until you get a license. Try to be careful, man. You know, begging to go to prison. Just, if it's all centered around one thing and it's booze, just stop. It's not hard. Mind over matter. You know? Okay. All right. Good luck, Ms. Ortiz. Thanks, Grant.
Did you wait the previous one?
Yes. Yeah. Hey. All right. What's new, man? I see that you are here, presumably for Mr. Lewis.
Yes.
Why has he never come here? I guess we're not that just... Hey, we love you. How are you?
I'm doing well.
Good to see you.
I should not just like.
Yeah, that's right. No one cares anyway. You complain until you're blue in the face, no one's going to do anything about it.
Very true. Mr. Poole came in to do his drug test. He was negative. All is good. It's gone well.
Remind me what we're doing with Mr. Poole, because I don't know.
MRP picked up a new case. Also got a case upstairs. We are in the process of getting stuff together to document that this is not what it sounds like.
Oh, that's right. This isn't Mr. Poole.
But he's been on house arrest. He's been doing drug tests and everything.
Right. Okay. I remember Mr. Poole now. Okay.
Two things I did want to clarify while we were here. You gave him permission to leave the house for medical things. I'd like to extend that to counseling if it wasn't already included. And for Christmas, just to be able to visit family in town, for like when the family goes to the aunt and uncle's house.
What is your position?
You said he didn't have any violations.
No.
I mean, I'm okay.
I don't know, but we haven't checked.
His parents going to his aunt and uncle's house, or the family's going for Christmas.
Come up, Mr. Poole. Tell me what's going on with your life now. What are you doing with yourself?
I'm just trying to work on myself. I'm staying at the house, so
Okay.
I'm just like working out and doing whatever, trying to get my schoolwork done. So I'm doing all my
Are you in high school or are you in college?
I'm a senior in high school.
You're a senior in high school.
I'm trying on my school right now.
Okay. How's that going?
It's going well.
Okay.
In my first semester.
You're what?
I'm about in my first semester,
Okay.
14th.
Are you seeing anyone? Counseling wise, are you seeing anyone? How does that work out?
It's online, but I was planning on doing it in person next week.
We'd like to get it online because, or excuse me, to in person because as you can imagine, trying to do it
You
online.
need proof first, right? That he's
Proof of what?
that he's gonna go actually see someone. You know, like he has an appointment, so we know he's not just gonna go visit friends.
How do you want to?
I don't know, maybe get a letter from the doctor showing that you have an appointment, that you're gonna go see him. What else are you requesting?
I just wanted to be able to go do the counseling that he's attending in person because it's per the counselor, and based on my experience doing the 20 years, it's significantly more helpful if you can actually do it in person instead of trying to do it through.
How often do you see this person? That's it? Okay. Do you want to do this on a weekly basis, or is this just a one-time deal now?
I think we should just do it whenever the counselor can, whatever the counselor is prescribing is the best course of action.
Okay. Of course, I'm okay with it. I just want proof.
Yeah.
I don't take anybody's word for anything. As much as I, admire and respect you, I don't trust anyone, right? Not you specifically, but
Understood. We will get you the documentation. Who do you want us to provide that to?
you can give it to Alicia. Yeah, she's here every day, so you can email it to her. That should be sufficient, and then we can come up with a plan. But you go to the counselor, and then you come back home. And if you don't straighten up and fly right, I'm going to be all over you. Do you understand? One false move again. This is not supposed to be a happy time for you. And I don't know what I need to do to get your attention. But next time, I will classify you as a danger, revoke your bond, and make it so high you will have teeth falling out. Do you understand?
Sir.
Take a seat.
Thank you, Judge. Back to your point. Do you have a preference on a reset date, Judge?
So,
Was it one day for Christmas? Do you use like Christmas Eve?
Just one day.
okay, I'm okay with that.
Okay.
Remember, using anything, if you are, no contact with any of the, alleged complaining witnesses.
Okay.
And I'm going to tell you now, if you get together with family members and they're family members that you don't get along with, and there's the potential that you end up in an argument or a fight or something, it's not worth it.
Yes.
You need to consider that wherever you're going. All right? Okay. I'm with you.
Thank you, Judge.
All right. Appreciate it first. Ready?
Always, Judge. Let's qualify that. I don't know what we're doing, but yes, right.
Come up. Come up.
Mr. Bledsoe. So I spoke with pretrial judge, I spoke with the coordinator. Per pretrial, he's tested positive presumptively, because it's sent to lab for confirmatory for alcohol and THC. I think they described his behavior as
Threatening.
well, I didn't get threatening, but
I got
And this is where the courtroom energy completely changes. The judge hears the word threatening, and suddenly the tone goes from routine hearing to full-on warning shot in court. Attitude matters more than most people realize. Disrespect can escalate consequences fast.
threatening. And I'm going to tell you now, I'm not going to have you, and I'm not going to stand for your threatening anyone in this court at any time. That is, every part of this is an extension of us. I don't care where you're going. I don't care what building you're in, whether you're in pretrial services, whether you're taking a drug test. It's unacceptable, and I'm revoking your bond, and now goes with you.
if I can, Judge, I don't believe there has been actually any evidence presented to warrant a
Hold on,
bond revocation.
She told me yesterday that there had been multiple threats.
So, all right, to circle back, there's a couple things. And speaking with pretrial, I have not received any information about threats. I have received information about cursing and rude behavior.
Yes, Judge. There
Don't
was
speak.
no threat of harm or anything like that. It was just more so attitude. He was making people in our office a little bit uncomfortable just with his demeanor and the things that he was saying, but none of it, to my knowledge, has been anything, putting people in danger, threatening danger, anything of that sort.
This is where I'll.
Have an open criminal case. You're to be humble and contrite. And when you're not, and when you're threatening, abusive, harassing, I'm going to take care of you and I will light you up like a damn Christmas tree. Do you understand? It is unacceptable, the behavior that you have displayed here with myself, with pretrial, with the people down over there. And if you don't straighten up and fly right, I'm going to be all over you. Do you understand? One false move again. This is not supposed to be a happy time for you. And I don't know what I need to do to get your attention. But next time, I will classify you as a danger, revoke your bond, and make it so high you will have teeth falling out. Do you understand?
Sir.
Take a seat.
Thank you, Judge. Back to your point. Do you have a preference on a reset date, Judge?
Tell me what he tested positive for.
It was THC and alcohol, Judge.
This is where I'll add that the court added bond conditions yesterday, so he had the magistrate.
I understand.
Okay.
He did have these magistrate orders in October, and I did see that he was instructed over it. It didn't have no alcohol, but it was
October what?
October
14th, 15th.
Give me the last name again.
Bledsoe, B-L-E-D.
This may be the most emotional moment in the hearing. The judge starts talking about people dying from DWI crashes every single day. And suddenly this isn't just about one defendant anymore. It becomes about public safety, repeat offenders, and how quickly one bad decision can ruin multiple lives.
Oh no, he's still smoking weed then. I mean, if they told him not to use any kind of illegal drugs, and he tested positive right now, give me the date, please. Come up, Mr. Bledsoe. You're not off the hook yet.
This is where I will repeat my assertion that since he's out on bond, he's entitled to a hearing where the rules of evidence would apply.
What we're doing right now.
Well, then I'm going to object to hearsay to anything and everything being heard by the court.
What day was the magistrate condition for no using, please? October 20th.
Don't forget my spiel about THC seltzers that I could buy at Specs that have no alcohol but have THC in them.
You are not to use alcohol. You are not to use illegal drugs. I'm going to give you the benefit of the doubt, and I'm going to test you again in 2 weeks from today. If you test positive for THC again, and I don't care what it is, I don't care if it's a gummy, I don't care if it's a joint, I don't care if it's Delta 8, if it's Delta 9, if it's Delta 352, whatever it may be, you will stay with me. Do you understand?
Yes, sir.
Get whatever records you need. But if you test positive for THC again, you're on notice now. You will stay with me.
Yes, sir.
Okay?
Thank you, Judge. Have a seat back in But did you have a preference on the reset date, Judge?
2 weeks, whatever you want.
Oh, I'm sorry, you're right. You said
And
2
I'll
weeks.
test them back and we'll see.
Do you want,
By then it'll be sufficient benefit that there's just no argument.
do you want him 2 weeks from today testing on that date?
Yeah.
Okay. We'll be. Thank you, Judge.
What's your name? You are Jonathan Leatherwood. Yes. Good morning, sir. So you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Officers dispatched to a crash in Harris County, Texas. Officers arrived and observed the defendant as a sole occupant in the driver's seat. They observed red glossy eyes, strong odor of alcohol, slurred speech, and unsteadiness. Complaining witness told officers she was sitting at a red light when the defendant rear-ended her. Complaining witness exited and walked over to defendant's car and observed an open can of beer in the cup holder. SFSTs conducted 6 out of 6 HGN, 5 out of 8 walk and turn, 3 out of 4 one-leg stand. DNCs were read and defendant consented to blood sample. His license is eligible and this is his first DWI judge.
Open container of beer while drinking, you say?
Yes, sir.
Mr. Leatherwood, I'm going to find that there's probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I'm going to put you in jail. You will not get any more PR bonds. Do you understand?
Yes, sir.
Do you have a valid Texas driver license?
Yes, sir.
Do you have liability insurance in your name?
Yes, sir.
Okay, I'm now taking away your privilege to drive. You are not allowed to drive. Do you understand? I'm also making that a condition of your bond. I would hope that you understand it's elementary that you're not to have alcohol in the car while you are driving. Do you understand?
Yes, sir.
You have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with Mr. Strauss. If he tells me he can't get a hold of you, you pick up a new case, you endanger my county, I'm going to revoke your bond. No more PR bonds for you. Do you understand? All right. I'm going to have you come up here, swear to us that you're not going to drive. I'll get you to Victoria where we'll have you sign a reset. After that, we'll get you with Felicia for your bond conditions, and after that, you're free to go.
The judge, we believe, Your Honor, what was in the car was an energy drink, Judge. It was not alcohol, Your Honor.
It's just what's alleged, Judge. I mean, I don't have a photo of the
Judge, he has no priors. We would ask you, Judge, to allow him to drive while on bond.
They're alleging he's got an open container of beer in the car while he's driving. I mean, you know, if you show me that it's not, I'll take it away. But I mean, they're telling me it's an open container of beer. So do this. Is the video here? Do you have anything?
Yeah, it looks like we have some body cam, Judge.
Hey, do you want to take a look real quick to see if you see something different?
Take a look.
No, I mean, we've got time. It's 9:45, you know,
Yes.
we've got all day. Well, not all day, but, you know, take a look real quick. I'll put this on hold if you find something different, you know,
Yes,
and
sir.
once they have time, they can go out, reach to the officer, see, hey, was it really an energy drink? Was it a beer? And let's see. But if he's drinking and he's in the car and they're alleging that, no, you know, there has to,
We'll go look at it.
yeah, sure, for sure. Mr. Leatherwood, heed this warning. You won't get another one. Do you understand? Okay, come on.
All right, Davis, come on up, stage 7.
Hey, Vic, what page? 17?
7, last name Davis.
Good morning, Mr. Davis. So you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
The complaining witness and the defendant are married. Officers were dispatched to a residence in Harris County, Texas. They met with the complaining witness who stated that she had called the defendant and noticed that he was intoxicated. The complaining witness then drove to the defendant's location to take his keys to make sure that he would not drive. The defendant
Smart. Wonderful.
The defendant refused to give her the keys. The keys ended up on the ground. The complaining witness went to pick the keys up, and the defendant started grabbing her, pushing her, and hugging her as they both fell onto the ground. The complaining witness said that she fell onto the ground and she felt pain and discomfort, and the defendant was on top of her. The officer noticed the defendant was much larger than the complaining witness, leading him to believe that the defendant falling on top of her would cause pain as well.
So did he intentionally assault? Was it an accident? I don't. Read it again. You said he fell on top of her. Isn't that what you said?
Yes, Judge. He hugged her, and then they both fell to the ground. And then he had fallen on top of her when they fell to the ground.
This is a specific intent crime.
I don't think we have an offense report, Judge.
Well, nevertheless, this is what we do now. This is the probable cause hearing. You gotta have it now.
This is a DVD case, Judge. I don't think that the complaining witness has been ripped yet.
Doesn't matter. We got what we got here, and I don't see intent to you. You know, in life, Mr. Davis, it's Davis, right? There are people who drink. They become very happy. You know, they're great to hang out with. They crack jokes. They're just the life of the party. And then there are those people, when they drink, they become the devil incarnate. They get horned. They just become terrible. If this strikes a familiar chord, don't drink. You know, it sounds like someone's trying to do something very loving, you know? Really. I'm going to find no probable cause now because I don't see intent, but just be careful. You know what I mean? Just, you got one life. Be happy and be nice. All right? Just take a seat for me, please.
All right, Judge, next is page 17. Laverne. Asia.
I'm sorry, I missed the page. I was like
17.
zoning. Miss Laverne, good morning. Ma'am, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
Any witness and the defendant were dating for 6 months. On 12/4, officers were dispatched to a residence in Harris County, Texas. They met with the complaining witness, who stated that the complaining witness and the defendant were at their uncle's house for food. When the defendant became angry, the complainant had received a call from another girl. Complainant called the girl back to prove she wasn't cheating, or he wasn't cheating. Defendant snatched the phone from complaining witness and began screaming at other party. Defendant grabbed complainant by the throat with her hand and struck him multiple times with a closed fist, causing pain. Complainant called police when the arguing calmed down. The witness stated he did not observe the fighting, but did hear defendant say, I hit you, and I'll do it again. No visible injuries were observed on either party.
Ma'am, I'm gonna find that there's probable cause to go forward with your case. Do we know, do you guys have the rep done? Do we know if he wants to continue to have contact with her?
The DVD case, Judge, and we don't have the rip on this.
Okay, I don't know if he wants to have contact with you, so until I know what his wishes are, I'm gonna order you not to have contact with this person. Do you understand? Ms. Laverne, I want you to understand that I'm gonna protect every person in my county. If I have to put you in custody, I'll do it in a heartbeat to protect everyone. Do you understand? There's a protective order that's been issued in this case. You need to get to know it. If you violate this protective order, the state can file a violation of protective order. It's one of the worst cases you can pick up. There's a residential restriction. There's things that you can't do. So take note and don't have any contact. Don't have any weapons with this person. Do you have any questions? I don't want to talk about the case. I'm just over the conditions. Do you have any questions? How old are you, man?
22.
You're 20. What do you do for a living?
I'm going to school.
Where do you go to school?
San Jacinto.
Okay. Do you work?
Yes.
What do you do?
A dancer.
A dancer.
Yes.
Did you want to apply for an appointed lawyer, ma'am? Okay. I'm going to order you also as a condition of your bond not to use alcohol or any kind of illegal drugs. I'm going to randomly test you. If I find that you're using, likewise, I'm going to revoke your bond. I'm not asking much from you. All I'm asking you to do is follow the law. Don't use alcohol. Don't use drugs. I'm going to test you. Do you understand? In fact, I think I'm going to send you for a test today because I want to know what, if anything, is in your system. Come back, and then I'm going to find you a lawyer, man. All right? Okay, please. Hi, Casey.
Hey, how you doing?
Two.
I do have a plea for you today on Mr. Bryant.
You said Mr. Bryant?
Yes, Jason Bryant.
Okay, good morning, Mr. Bryant. Oh,
So, it is actually not a second.
Your Honor, if I may, it's not a second because our investigator reached out to the county and found that the records were expunged. So,
it's still,
Your Honor, under the code, you can't use expunged records for purpose of enhancement. And we reached out to appellate to confirm that as well as other people, as well as from the AG's office. And they've also.
so what happened? Did it get dismissed?
So,
Expunged?
it's a conviction that was
You still
expunged.
enhance it to a second?
We can't use
Not
the
with an
expunged records,
exception.
Your Honor.
Technically, they shouldn't even know about it.
Yes, that's the issue. So for that reason is why we put a reduction to a first.
So
Yes.
we could refile it as a first, but we're not allowed, like for our appellate division, we can't use it for anything else, like to charge to a second.
Here's the thing. You've already had one that's dismissed. You now pick up another one, right? You know, when do we say when?
Complainant by the throat with her hand and struck him multiple times with a closed fist, causing pain. Complainant called police when the arguing calmed down. The witness stated he did not observe the fighting, but did hear defendant say, I hit you, and I'll do it again. No visible injuries were observed on either party.
Ma'am, I'm going to find that there's probable cause to go forward with your case. Do we know, do you guys have the rep done? Do we know if he wants to continue to have contact with her?
The DVD case, Judge, and we don't have the rip on this.
Okay. A day, do people die in Harris County because of the DWI?
Every day, all the time.
Every freaking day. Every single day. And the problem here is that what I have found when we go too low on punishment with repeat offenders, I have found that they wrap their car around the pole the next week. And that's why I have an extremely hard time of taking another proverbial slap on the wrist if you've even had one dismissed. Because who's to say you've learned anything? Tell me about the facts, will you, please?
Yes, Judge. One moment, Judge. So the facts were the officers were dispatched to a major crash call, and a witness stated he arrived at the accident, observed the defendant sitting in the driver's seat of the vehicle with the engine still on, and saw the defendant get out of the vehicle and sit by a tree. The officers observed the defendant to be sitting under the tree near the vehicle. And
Did you say there was an accident?
It was a single car accident,
He
Judge.
had hit a tree, and then he was being treated by HFD upon the arrival of the officers. And the defendant's vehicle had right bumper damage and windshield down and the glove box open from the accident. And that's when the officers found
Two guns.
a loaded handgun on the sidewalk and another single 9mm near the vehicle. And then the officers then observed bloodshot, watery eyes, slurred speech, and a strong odor of alcohol coming from the defendant. And the defendant was unable to walk due to the injuries from the accident. So the defendant admitted to driving, crashing the vehicle, and owning the firearm. He also admitted to consuming the alcohol. And that's when the defendant was transported to Memorial Hermann by ambulance and was unable to perform SFSTs due to the hospital visit. And a blood draw was performed.
What was the blood?
He came back at 153.
Did you guys enhance it to a 15 above?
No, Your Honor, we did not.
How did they even charge it as a second when you're telling me that it's been expunged?
Originally, it was charged using the expunged records because they only ran an NCIC, and for some reason it came up on NCIC when it shouldn't have. That's the issue.
Forever, for the rest of your life, you now see, even if it's expunged, people still see it. It doesn't matter. You know, in the future, going forward, what do you think is going to happen if you get pulled over and an officer looks at your record? Right. From now on, you're looking at a minimum of 30 days in jail. I'm going to tell you now, Mr. Bright, I don't want to take this. I don't think it's fair. You know, I don't on any seconds because, you know, there has to be consequence for behavior. And it's not fair. This is the last time you will get a proverbial slap on the wrist. I want you to understand that. Anytime you get pulled over, they're going to see all this. You will get taken down. All you have to do is push a button on your freaking phone. $30 to $40 on an Uber will take you anywhere you need to go. Do you understand how much money have you paid them to represent you? How much money have you paid to represent on the first freaking DWI? And now you're back. I'm going to tell you, if you act like a child, I'm going to treat you like a child, and I'm going to put you over my knee, and I'm going to spank you like a little child. You come back here, but I'm going to do it with a ton of jail time. Do you understand? Sir. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal once you accept this agreement. You can never change this or undo this. Do you understand? How to plead to the offense of driving while intoxicated. I will find you guilty. I will sentence you to 3 days in jail. I'll give you credit for 1. I'm going to suspend your license for a year. Do not drive until you get a license. I am also now going to hit you with these DPS surcharge that you will be required to pay. That is a $3,000 surcharge you're going to be required to pay. You will also be required to pay the court costs, which are around $400 to $500. And I'm going to tell you, we're going to get it one way or the other, because if you don't, every $100 that you owe, you will be sitting 1 day in jail. So you can imagine on a $35,000 to $4,000 bill right now that you're going to get, how much you will sit in jail. Sir. I want you to understand that we will not tolerate DWIs in Harris County, and we're going to get blood one way or the other. You understand? Yes, sir. It's just not fair when it's so easy to find another way. You know, I like to drink. I like to drink a lot. I love my meals really, really spicy. And I love to go out with my wife. How do you think I do it though? Right. And then I can just be towed, you know? But that's the responsible thing to do. And I hope that you really get it.
These real cases remind us that every decision has consequences, and one mistake can change lives forever. What do you think about the judge's rulings in today's hearings? Were the decisions fair, or should they have been different? Share your thoughts in the comments below. If you enjoyed this video, please leave a like, subscribe to Trial Archives, and turn on notifications so you never miss our latest courtroom videos. Thanks for watching, and we'll see you in the next case.